Are you sure you are in this case?
Yes, sir. James Doughty against Bristol. I appeared for Bristol, my lord. I conducted the trial personally.
Who is Honorable Bayo Idowu? Who is Honorable Bayo Idowu?
I do not know him, my lord.
And SC Odofin?
I do not know him, my lord. It was Tokwe Temoku that appeared for the
ones who are adopted.
Humbly, my lord.
Just a moment. At the last adjourned date, okay. They made a mistaken appearance before Tokwe Temitokun appeared for the claimant and Obafemi Agaba appeared for the defendant. Okay, with Irene Momo, that day, And that is what I don't like. Because see, I was like,
Respectfully, my lord, my colleague has been online, but she has not been let in.
that is the Tokwe Timokun.
Irene. Humbly, my lord. I'm so sorry for
Tokwe
Timokun. I'm here, my lord. For Timokun, I'm here, my lord.
Okay, announce your appearance.
As the court places. May please the honorable court.
Announce
May
your
please the honorable
appearance
court,
now.
A.E. Adegori Esquire, my lord. I hold the brief of Tokwe Timokun. My lord, I appear for the plaintiff.
You hold the brief of
Tokwe Timokun Esquire, my lord.
for
the plaintiffs, my lord.
Plaintiff in NIC.
Yes, ma'am. Oh, so sorry, my. I'm so sorry, my lord, for the claimant.
No, thank you. All right.
Respectfully,
yes.
sir. I'm Obafemi Agaba, and Irene Momo is appearing with me for the defendant. She's been online, my lord, but she has not been allowed in.
Yes, but I have written your appearance. I've finished. I've written A.E. Adegoroye already on the next line. So where do I write her?
As the court places.
You understand the point?
As the court places.
We take mental notice of her presence. Yes, the case is for what?
The case is for judgment, my lord.
Adegoroye.
My lord, the case is for judgment.
Ah. Okay, this is the judgment of the court. This is the judgment of the court. This is a 2018 case with 3 volumes of files spanning 1,795 pages. The claimant took out a complaint on 9th March 2018 against BGI Aviation Technical Services Nigeria Limited, seeking for 3 reliefs and 2 in the alternative. The defendant entered a memorandum of appearance and a notice of preliminary objection on 12th April 2018, and a statement of defense via a motion filed on 10th May 2018. The preliminary objection was dismissed by AA Adeomi Moje on 19th July 2018. The defendant, BGI Aviation Technical Services Limited, was substituted with Bristol Helicopters Nigeria Limited via a motion filed on 24th October 2018. By a motion filed on 17 January 2019, the claimant amended his complaint and statement of facts. The amended form of complaint and statement of facts was filed on 6 March 2019. By a motion of 16 May 2019, the defendant filed a consequential amended statement of defense and a counterclaim, and amended same by a motion filed on 6 June 2019, and a fresh copy was filed on 25 June 2019. The claimant filed an amended reply on 21st December 2020. Claimant applied to amend his statement of facts by a motion of 13 February 2020. The defendant filed a further amended statement of defense on 23rd February 2021. By a motion filed on 11th October 2021, the claimant applied to file a consequential amended reply. At the hearing, the claimant testifying as CW1 adopted his witness statement of 21st December 2020 at pages 776 to 792 in volume 1 of the court file, and his deposition in reply dated 11th October 2021 at pages 1536 to 1547 in volume 3 of the court file, while CW2 adopted his witness depositions of 21st October 2020 at pages 862 to 872 in volume 1 of the court file. The defendant's witness, DW1, adopted his witness statement of 23rd February 2021 at pages 1476 to 1485 in volume 3 of the court file, while DW2 adopted his deposition of 6 June 2022 at pages 1595 to 1603 in volume 3 of the court file. Brief relief sought by the claimant. By the process adopted by the claimant, the relief sought are, as in the first statement of facts filed on 21st December 2020. The reliefs are as follows: a declaration that the dismissal of the claimant from the employment of the defendant on an unproven criminal allegation of theft and without giving the claimant a fair hearing and without complying with the terms and conditions that governed the claimant's employment with the defendant, communicated to the claimant via a letter dated the 19th of December 2017, is ultra vires the defendant, illegal, unconstitutional, null, and void. 2, declaration that the appointment of the claimant with the defendant is valid and subsisting till the date of the judgment, with all the rights and privileges attaching to the payment of backlog of his salaries and other benefits, including his redundancy benefits entitlements calculated as follows. A, salary arrears, basic housing, transport, totaling 406,814. Supervisory allowance, 7,000 242 naira per month equals to 414,056 naira. Total 414,056 naira times 14 months of arrears equals to 5,797 naira, 784 naira from December 2017 till B. Then 3 months in lieu of notice at the rate of 406,814 per month. BHT, i.e. basic health and transport. Basic is supplied housing, transport, total 406,814 times 3 months equals to 1,220,444 kobo. Redundancy is calculated there, all amounting to 38,444,016 naira. Then 30% of the total value of 38,038.44 million is 11,133 naira, 201 naira. 533,201 naira. E, leave allowance for 2018, 15% PHT annually for 2010 equals to 732,266 naira. F, 13 months for Xmas bonus equals to 241,724 naira. G, 5% gratuity, which was 2 million naira. Grand total is 57,997,705 naira. Then 3, an order directing the defendant to pay to the claimant his redundancy benefits and other entitlements assessed at 57,997 naira, 705 naira. Or in the alternative, 4, a declaration that the dismissal of the claimant from the employment of the defendant on an unproven criminal allegation of theft without giving the claimant a fair hearing and without complying with the terms and conditions that governed the claimant's employment with the defendant, communicated to the claimant via the letter dated the 19th of December 2017 is wrongful and illegal. An order directing the defendant to pay to the claimant special and general damages of the sum of 57,997,705 naira. Defendant's counterclaim. The defendant counterclaims as follows. A, an order of this honorable court compelling the claimant to pay the defendant the sum of 14,797,400 naira. An order of this honorable court compelling the claimant to pay the defendant the sum of 50 of fidelity and the terms and conditions of his employment. C, an order of this honorable court compelling the claimant to pay the defendant the sum of 9 million bearing cost of defending this suit. Case of the claimant. It is the case of the claimant who testified as CW1 that he was employed by Pan African Airlines on 1st October 1997 and later seconded to the defendant. He was issued a staff handbook by the defendant. He rose through the ranks to the position of a store supervisor. He got a call from Kayode Orebie, the supply manager, inviting him to Lagos on 7th December 2017. All the flights were fully booked, so he could only get to Lagos on 11th December 2017. In the office of the supply manager, in the presence of the supply manager, the company lawyer informed him that there was an allegation leveled against him by one Aniete Ebo. It's me? That he gave him aircraft parts to sell. he was never given details of the said allegation. I told them it was a false allegation and I was handed a letter of suspension the same 11th December 2017. Around 16 December 2017, my co-workers were paid salary, but I was not paid my salary in compliance with the terms of the suspension, which was that I would be on full pay. I was invited to Lagos for a disciplinary panel fixed for 19th December 2017. I denied the allegation and requested that my accuser, the said Mr. Anete, be made to appear before the panel to confront me for questioning, but the request was not granted. The panel called for a 30-minute break, and on resumption, I was handed over a summary dismissal letter dated 19th December 2017 on an allegation of stealing and theft. That the defendant lost his contract and the workers declared redundant was where I served till my dismissal, and negotiation on redundancy benefits concluded between the defendant and the workers' union to which I belong before my dismissal. I was dismissed hurriedly without following the procedure stipulated in the terms and conditions of service governing my appointment. As a worker of 21 years service, by the redundancy computation as agreed, I was entitled to the sum of 57 million naira, 997,705 naira. The negotiation of payment of redundancy benefits was eventually concluded in March 2018. Testifying in reply, CW1 denied the statement of defense and restated his case. Testifying as CW2 was Damisa Simpa. It is his testimony that he was the third national vice president of the Claimants Union, National Union of Air Transport Employees, NOATE, that he represented the union and witnessed the proceedings of the defendants panel against the claimant, that he, together with the claimant, insisted on the appearance of the said Anete, and the panel went for a 30-minute break and came back and handed the claimant a dismissal letter. That the defendant lost his contract at Escravos and a large number of workers of the defendant in Escravos were declared redundant, and negotiation on redundancy benefits started. A large number of workers of the defendant For a large number of workers of the defendant declared redundant. The redundancy negotiations were almost concluded when the claimant was dismissed, and the negotiations were concluded in March 2018. Case of the defendant. It is the case of the defendant through DW1. Obafemi Joseph, a manager of the defendant, that the claimant was first employed by BGI Aviation Technical Services Nigeria Limited, which later merged with the defendant, and the staff of BGI became staff of the defendant. That the claimant had worked as its employee for 20 years. That the claimant was suspended with effect from 11th December 2017, pending full investigation on the matter. That the claimant was given full facts of the allegation of theft of aircraft spare parts in collaboration with one Mr. Anete Obong, a former staff of the defendant. That after finding the claimant guilty of the theft, the claimant was dismissed on 19th December 2019. That the redundancy was not being considered when the claimant was being investigated for gross misconduct, and he was dismissed before the redundancy exercise. That the police investigated the theft, found a prima facie case against the claimant, and charged him to court, which trial is ongoing in charge number ID 7882/6/2008 FRN, that's Federal Republic of Nigeria versus Anete Felix Obong and two others. So it was no longer healthy, wise, and prudent for the claimant to remain in the employment of the defendant. That the defendant counterclaims against the claimant by repeating the statement of defense, and in addition state further that between January and June 2017, the claimant was involved in the unlawful conversion of the following helicopter parts belonging to the defendant from his base at S. Kravos. The parts are 1, helicopter rotor servo, 2, antenna, 3, fuel control unit, and 4, tail rotor blade. The claimant had custody of and access to the defendant's storeroom where the parts were kept and unlawfully took out the parts with intention to use the said parts and any proceeds from the sale for his personal and selfish gains. That the total market value of the parts in dollars is $36,991, which is approximately 14,796,400 naira. DW2 was one Tolu Olubajo, a director in the defendant. His testimony is materially the same with the DW1, except that by his own calculation, $36,991 is equivalent to 11,319,246 as against 14,796 by DW1. It will serve no useful purpose to further reproduce a summary of the evidence of the DW2 hearing. Final written address of the defendant. In his final written address for the defendant filed on 22nd March 2023, Lanet Agaba formulated 4 issues for determination as A, whether the dismissal of the claimant was proper, B, whether the claimant is entitled to redundancy benefits and payment of salary after dismissal, C, whether the claimant is entitled to relief sought, D, whether the defendant has proven his counterclaim. Learned counsel answered questions A and D in the affirmative and B and C in the negative. The defendant counsel also filed a reply on 12 January 2024. Reference shall be made to any part of the addresses as the need may arise in the course of this judgment. Final written address of the claimant. In his final written address for the claimant dated 4th January 2024, Lanet Tope formulated 4 issues for determination as follows. 1, whether paragraphs 24E to I and N of the DW1 deposition document standards are marked as exhibits OJ4 and OJ12 are liable to be struck out as being inadmissible. 2, whether the summary dismissal was not void or wrongful for want of fair hearing and violation of the condition of service. 3, whether the claimant is entitled to his claim sought in this case. 4, whether the defendant has proven his counterclaim. Learned counsel answered all the questions in favor of the claimant. Reference shall be made to any part of the address as the need may arise in the course of this judgment. Court's decision. The issues formulated by both counsel are similar. The court shall adopt the issues formulated by the learned counsel for the defendant, treating the first issue of the claimant counsel as a preliminary issue. On the preliminary issue, it is the submission of the claimant counsel that paragraph 24E to I and N of DW1 deposition document standards are marked as exhibits OJ4 to OJ12 are liable to be struck out as being inadmissible as they are facts not directly witnessed by the DW1 and thus hearsay evidence. It is to be noted that the defendant is a company and can only act through its officers, and DW1 is the defendant's manager. He is a witness competent to so depose by virtue of his position as deposed in his paragraph 2. This leg of the objection fails and is dismissed. On exhibits OJ14 to OJ4 to OJ12, all emails, it is the submission of counsel that the documents failed to meet the requirement of admissibility under Section 84 of the Evidence Act. It is the finding of this court that the OJ series of exhibits are accompanied by a certificate of compliance in line with Section 84 of the Evidence Act, and that is Exhibit OJ 14. The objection fails and dismissed. I can't hear you to be sure whether we are together, counsels.
As the court pleases, my lord.
Thank you. At least that tells me we are together.
Yes, my lord.
Merits of the case. A, whether the dismissal of the claimant was proper. It is the submission of the claimant that he was not given fair hearing, that the allegation was not proven. It must be noted that this is a master-servant relationship, so issue of fair hearing is not such a strong or relevant one. Compliance with the terms and conditions of service is the issue. In this regard, claimant counsel contended that the defendant failed to comply with the terms and conditions of service, which provides at page 31 that consultation should be made with the manager and the union before a staff is dismissed, and this was not done. The defendant counsel submitted that it is for the court to find whether the dismissal was done in accordance with the terms and conditions of the contract between the parties. Exhibit JD3 in this case, which provides for dismissal for gross misconduct, and the claimant was dismissed for gross misconduct. It is also the case of the defendant. It is also the submission of the defendant that the police investigated the theft, found a prima facie case against the claimant, and charged him to court, which trial is ongoing in charge number ID/7882/C/2018 FRN versus Anette Felix Obong and 2 others. So it was no longer healthy, wise, and prudent for the claimant to remain in the employment of the defendant. Now, dismissal is not a palatable thing in the world of labor. Exhibit JD6, the dismissal letter, hinges the dismissal on the finding of guilt of stealing aircraft parts, in spite of the claimant's denial of the allegation before the disciplinary committee. It is my firm opinion that the defendant was not entitled to so do while the trial for the theft was still pending in court. The offense of selling or theft is a criminal offense for which the offense of stealing or theft is a criminal offense for which only a court with the competent criminal jurisdiction can find anyone guilty of. The Supreme Court in Federal Civil Service Commission versus Laoye, 1989-2 Nairobi Law Report, Part 106, page 652, at pages 679, held that for once such criminal allegations are involved, care must be taken that the provision of Section 33(4) of the Constitution are adhered to. It is not so difficult. It is not so difficult where the person so accused accepts his involvement in the acts complained of, and no proof of the criminal charges against him would be required. He has, in such a case, been confronted with the accusation, and he has admitted it. You could first discipline after. But in the real enactment of life drama, this is never the case. People very seldom, if at all, admit of their involvement in criminal acts. In his concurring judgment, Oputa JAC, as then was stated at page 707, he said, When anyone is accused of a criminal offense, he should, in his own interest and in the interest of truth and justice, be tried by the ordinary courts of the land. No hush-hush inquiry will take the place of open trial. The right to fair hearing comprehends and includes the right to be heard in open court in defense of one's character and good name when accused of misconduct amounting to a criminal offense. The defendant had a choice of terminating the claimant's appointment in line with the condition of service or waiting for the outcome of the trial. Accordingly, the dismissal of the claimant was wrongful and I so declare. The dismissal of the claimant ought to be and same is hereby remitted to termination.
As the court pleases.
As the court pleases.
B, whether the claimant is entitled to redundancy benefits and payment of salaries after dismissal. It is the case of the claimant that, and I quote, the defendant lost his contract and the workers declared redundant in ex gravos where I served till my dismissal and negotiation on redundancy benefits concluded between the defendant and the workers' union to which I belong before my dismissal. As a worker of 21 years service by the redundancy computation as agreed, I was entitled to the sum of 57,997,705 naira. The negotiation of payment of redundancy benefits was eventually concluded in March 2018. It is also the testimony of CW2 for the claimant that, and I quote, the defendant lost his contract at Escravos and a large numbers of workers of the defendant in Escravos were declared redundant and negotiation on redundancy benefits started for a large number of workers of the defendant declared redundant. The redundancy negotiations were almost concluded when the claimant was dismissed and the negotiations were concluded in March 2018. It is, however, the case of the defendant that, and I quote, a redundancy was not being considered when the claimant was being investigated for gross misconduct, and he was dismissed before the redundancy exercise. In the first place, the testimony of the claimant is contradictory. He said negotiation on redundancy benefits were concluded between the defendant and the workers' union to which I belong before my dismissal, and later said the negotiation of payment of redundancy benefits were eventually concluded in March 2018. Meanwhile, the claimant was dismissed on 19 December 2017. CW2 said, CW2 said a large number of workers of the defendant in Escravos were declared redundant. A large number of workers will not automatically include the claimant unless it is so shown, and it has not been so shown. I have taken a look at Exhibit DC2, the redundancy agreement tendered by the claimant. It is dated 20th March 2018. The opening paragraph provides as follows. After much deliberation by all the parties concerned, the following terms were agreed. 1, that the company shall declare redundant some employees effective from 31st March 2018. It is to be noted that redundancy negotiations is a normal prelude to a declaration of redundancy. See Ovivia and others versus Delta Steel Company Limited 2023 LPLR 40660 Supreme Court SC, where the Supreme Court held. An employer who wants to declare redundancy shall use his best endeavors to negotiate redundancy payments to any discharged worker who is not protected by the regulations made by the Minister of Labor under Section 20, subsection 2 of the Labor Act. Now, the claimant was dismissed in December 2017. As at 26 March 2018, Exhibit DC2 was only an agreement to declare some workers redundant effective from 31st March 2018. It is true, therefore, as contended by the defendant, that as at the time of the allegation against the claimant, his trial and dismissal, no redundancy was yet declared, so contemplated. The redundancy was not to affect all staff, but some staff. How the claimant is affected by the contemplated redundancy that was declared 3 months after his dismissal is left to imagination and speculation, which the court is forbidden to engage in. This issue is resolved in favor of the defendant.
As the court places.
C, whether the claimant is entitled to the relief sought. The court has found that the dismissal was wrongful and remitted same to termination. The court has also found that the claimant was not entitled to redundancy benefits after dismissal. It follows also that the claimant is not entitled to redundancy benefits after termination. Now, the termination can only be in accordance with the terms of contract between the claimant and the defendant and must be in terms as provided by the employment contract, which is Exhibit JD 11 in this case, the terms and conditions of service of Pan-African Airlines Nigeria Limited. Although this document does not carry the name of PGI Aviation Technical Services Nigeria Limited, the company that first employed the claimant, or the name of Bristol Helicopters Nigeria Limited, the defendant hearing, there must be an explanation known to both parties, and they both agreed that the contract document is the condition, that the document is the condition of service between the claimant and the defendant, as it was pleaded, tendered, and admitted as such without objection from the defendant, either at trial or in the final written address. From Exhibit JD 11 at page 25 under the heading Termination of Appointment, it is provided as follows. Every employee terminated from the services of the company shall be given 1 month service in writing or 2 months salary gross in lieu of notice and gratuity, as in 1A above where applicable, and 3 as in 1B above where applicable. 1A and 1B referred to are to be found at pages 24 and 25 under the heading Retirement Gratuities, and it provides as follows. The company will pay retirement gratuities to employees as stated below. 1A, employees who have served less than 10 years continuously, 2 months basic salary for each year and part thereof. 1B, employees who have served 10 years and above continuously, 2 years and half month salary, emoluments, basic housing and transport for each year and part thereof. Now, from the above provisions of the terms and conditions of service, it follows that the claimant is entitled to 2 months salary gross in lieu of notice and also gratuity. And the gratuity is as in 1B, since he has served for a period of 20 years, which falls under 10 years and above continuously, and he is therefore entitled to gratuity to be calculated at 2.5 months total emoluments, which is basic housing and transport for 20 years, and I so declare. D, whether the defendant have counterclaim. The defendant counterclaims against the claimant as follows. The claimant was involved in the unlawful conversion of the following helicopter parts belonging to the defendant from its base at Escravos. The parts are tail rotor, servo, antenna, fuel control unit, and tail rotor blade. That the total market value of the parts is $36,991 US, which is approximately 14,796,400 naira. However, it is also the case of the defendant in respect of the theft of helicopter parts as follows. That the police investigated the theft, found a prima facie case against the claimant, and charge him to court, which trial is ongoing in charge number ID 7882C 2018 FRN versus Agnete Felix Obong and 2 others. For this court to find the claimant liable for payment of the cost of the helicopter parts is for this court to find the claimant guilty of the offense without trying the claimant for the offense while the trial is still ongoing at the Federal High Court. This court declines invitation to rascality. This issue is resolved against the defendant, counter-claimant, and in favor of the claimant, counter-defendant. For the avoidance of doubt, the court hereby declares and orders as follows: a declaration that the defendant could not validly dismiss the claimant for an allegation of crime for which trial was still pending at the Federal High Court. B, an order of court reverting the dismissal to termination. C, an order that the defendant pays the claimant 2 months' salary gross in lieu of notice within 30 days of this judgment. D, an order that the defendant pays the claimant gratuity to be calculated at 2.5 months total emoluments, which is basic housing and transport, for 20 years within 30 days of this judgment. E, an order dismissing the counterclaim of the defendant, each party to bear its cost. This is the judgment of the court, and it is entered accordingly.
As the court pleases.
Yes. Let me hear Ade Goroye. Ade Goroye. Agaba.
Respectfully, my lord,
My
I want to thank my lord.
Was terrible. My lord, we appreciate the erudite judgment of the court and the industry put into same.
Who is this?
This is Akure, my lord.
I appreciate the court. Yes, Agaba.
My lord, we thank my lord for the erudite judgment, and we appreciate the court. Thank you, my lord.
Thank you, gentlemen. You can pick up a copy of your judgment tomorrow.
As the court pleases. We'll go to my lord.
Pleases.
Thank you, my lord.
AK 32 2018, John A. Audu and National Youth Service Corps. Appearances.
May it please my noble lord, E.J.
Yes.
Asagbeni.
EJ.